Dear friends, welcome to my channel, and today we are going to discuss an important aspect of departmental inquiry. Dear friends, during last many videos we have discussed various aspects of departmental inquiry, and we have also discussed various grounds on which a government servant can defend himself in the tribunal or in the court when the departmental inquiry results into any major penalty or penalty like dismissal or removal from service or any other penalty. Dear friends, today we will discuss what is the law pertaining to the report of inquiry officer. Dear friends, let me recap here that when a government servant is charge sheeted by the disciplinary authority, normally the disciplinary authority himself will not take up the task of conducting an inquiry in order to avoid allegations of bias and prejudice. Therefore, often we see that after the charge sheeted employee submits his written statement of defense in reply to the charge sheet or the memorandum of charges, then after having applied the mind to the written statement of defense, if the disciplinary authority comes to conclusion that the written statement is not acceptable or the charge sheeted employee has not given befitting reply and he has denied the charges, then it becomes necessary to hold an inquiry to prove the charges against the charge sheeted employee. Under such circumstances, the disciplinary authority then will appoint any officer who is substantially higher than the charge sheeted employee, and that officer will act as inquiry officer. Now the task of inquiry officer begins when he is appointed. The disciplinary authority will forward the charge sheet and the reply thereto along with all the documents, list of witnesses if any, to the inquiry officer, and inquiry officer will issue notice to the charge sheeted employee, and then actually presenting officer will examine the witnesses and prove the documents in support of the allegations against the charge sheeted employee. Similarly, the charge sheeted employee also will examine his witnesses if any, and both parties will cross examine the witnesses produced by each other party. After everything is done, after the final submissions from both the sides, everything is done, then the inquiry officer will appreciate the evidence that has come on record from both the sides, and after appreciation of evidence he will prepare his report. In that he will say that the charges against the charge sheeted employee are proved or not proved. Now when the charges are not proved, matter will come to an end, but when the charges are proved according to the report of inquiry officer, at this stage it is very necessary that the report of such inquiry officer, and dear friends, let me clarify here, this report shall be submitted by the inquiry officer to the disciplinary authority who appointed him as an inquiry officer. Then the same report will have to be forwarded by the disciplinary authority to the charge sheeted employee, and the charge sheeted employee will be called upon to submit or make a representation against the report of inquiry officer in which charges are held as proved. After the receipt of such representation against such inquiry report, the disciplinary authority will apply his mind and come to conclusion whether further process is required. It is only when charges are proved and after representation is received, the disciplinary authority comes to conclusion that the charges are proved and the reply or the representation of charge sheeted employee did not make much difference in his opinion, and he proceeds to impose or propose to impose a penalty. Then at that point of time, the disciplinary authority will issue a show cause notice calling upon the charge sheeted employee to say or to submit explanation as to why the proposed penalty will not be imposed upon him. Now dear friend, this is the procedure. Now what if now there are two important stages. Number one, the report of inquiry officer being given to the charge sheeted employee and giving him an opportunity to make a representation there against. This is one stage. Second stage is when the charge sheeted employee is given a show cause notice as to why the proposed penalty will not be imposed. Dear friends, let me remind you a famous case decided by the Constitution Bench of Supreme Court, that is Managing Director ECIL Hyderabad versus B. Karunakar. In this case, the Constitution Bench was called upon to decide as to what is the effect of not giving the copy of inquiry report or not giving an opportunity to the charge sheeted employee to make a representation against such inquiry report in which charges are held proved. Dear friends, here Supreme Court, that is Constitution Bench of Supreme Court, laid down that this may happen in cases where the departmental or the relevant rules under which the inquiry proceedings are held, the rules may be silent with regard to providing the copy of inquiry report to the concerned charge sheeted employee, or the departmental rules may not direct or may not provide that the copy of the report should be forwarded to the employee concerned. Secondly, there may be a case that employee is not aware of his right and he may not demand. Supreme Court said even when the rules are silent or even when employee does not ask for the copy of the inquiry report, it is mandatory. It is a mandatory requirement of law, that is principle of natural justice, that the report of inquiry officer must be given to that employee so that he will make a proper representation against the inquiry report and he will point out what are the defects in the inquiry report, so that when the disciplinary authority will apply his mind to that report, he will also have the representation there against pointing out the defects in the inquiry report. And if this is not followed, then the inquiry gets vitiated from that stage ahead. Therefore, when such inquiry gets vitiated, even if in such inquiry any penalty is imposed, that penalty is bound to be quashed and set aside in the court. It is not sustainable in the court. Now, Supreme Court has said in this case that inquiry breaks into two parts, two stages. Number one, when the inquiry officer concludes the inquiry, that is the departmental proceedings, and prepares his report and he submits his report to the disciplinary authority, then the employee concerned has to be given the copy of inquiry report and he has to be given an opportunity to make a representation against that. This is the first stage. The second stage in some cases may not arise, where the inquiry report itself has given a clean sheet and charges are not proved. Second stage may not arrive. And the second stage, when the charges are held proved and the employee makes his representation, that is not appealing to the disciplinary authority, then disciplinary authority will issue a show cause notice, that is the second stage. These both stages are very vital from the point of view of the principles of natural justice, and if that opportunity of making a representation against the inquiry report is not given to the employee, it results into violation of principles of natural justice, and accordingly it also results into violation of article 311 2, and it also results in violation of article 14 of Indian Constitution. Therefore, dear friends, now the law is very clear that even if the rules under which inquiry is held are silent or they say otherwise, then also the employer or the disciplinary authority is bound to give the copy of such inquiry report to the employee concerned, and employee is entitled to make a proper and effective representation against such a report. Dear friends, today we have dealt with this one specific stage which, if not followed, will vitiate the entire inquiry proceedings, and the imposed penalties in such cases will not be sustainable in the court. Now dear friends, in next video I will deal with another important aspect of this stage. Till then, goodbye, and don't forget to subscribe, like and share. Thank you.